Good afternoon, everybody. My name is Amanda Teo, and I am the Executive Director for the Rappaport Center for Law and Public Policy. On behalf of the Rappaport Center, our Faculty Director, Dan Kanstroom, and our Center Assistant, Abby Shingo, a very warm welcome to everybody who is joining us here today, both in person and online. As always, this program is being recorded and will be made available on our BC Law YouTube channel afterwards. I want to begin this event today with a little bit of bittersweet news that's personal to the center. Those of you who have come to our events consistently know how invaluable Abby has been to our work. Abby is graduating this May with a master's from BC and has obtained a very competitive spot in a training program with National Grid. Abby, we are so proud of you. We are so thrilled for you, but it is such a loss for the center and for BC Law. So on behalf of the entire Rappaport community, thank you. Congratulations. She didn't know I was going to be embarrassing her, so sorry, Abby. Turning to the program here today, I want to start just by recognizing that for many of us in the audience, myself included, the topic of discussion today is not just urgent and timely, it is deeply, deeply personal. About 30 years ago, I made the decision to forego citizenship from the country of my birth and to become naturalized as a U.S. citizen. And acquiring citizenship by choice rather than by birthright has meant that citizenship has always been an active commitment for me, a matter of practice, not just a matter of status. And it's that commitment to nurturing the ideals of this country that led me here to the Rappaport Center, where we do our work each and every day to sustain and nurture civic responsibility and public service. At this moment, there are so many immigrants, to use Professor Motomura's term, Americans in waiting, who are anxious about what the future holds for them. And quite frankly, there are many of us who have citizenship, whether by birth or by choice, that are also Americans in waiting. We also nervously anticipate or dread what the news is going to be the next morning. And so while our two panelists here today can't offer us necessarily certainty about that future, I am deeply, deeply grateful to have them here. With us today are two not only incredibly knowledgeable and well-respected professors of law, but also two empathetic and committed attorneys for whom immigration law is not just a scholarly enterprise, but really a calling. And I'm thrilled to welcome them. Hiroshi Motomura is the Susan Westerberg Prager Distinguished Professor of Law and Faculty Co-Director for the Center for Immigration Law and Policy at the UCLA School of Law. He is the author of Immigration Outside the Law, published by Oxford, Americans in Waiting, again by Oxford, and he is the co-author of Immigration and Citizenship, Process and Policy from West. He serves as a non-resident scholar of the Carnegie Endowment for International Peace and as a member of the International Migration Review Editorial Board. He was awarded a Guggenheim Fellowship and a Rockefeller Foundation Bellagio residency to write his latest book, for which he is on a book tour, Borders and Belonging, Toward a Fair Immigration Policy, which was published in January of this year by Oxford University Press. And fun fact, he is also featured, my kids love this fact the most, in the Try Guys video, the Try Guys Try Immigrating to America, which is available on BuzzFeed Video. Daniel Kanstroom is the faculty director for the Rappaport Center. But in case you need more information than that, he is founder of the Boston College Immigration and Asylum Clinic and co-founder of the Post-Deportation Human Rights Project. He has represented hundreds of clients in state and federal courts, written amicus briefs for the U.S. Supreme Court, organized innumerable public presentations. Professor Kanstroom is the author of Aftermath, Deportation Law in the New American Diaspora from Oxford, Deportation Nation, Outsiders in American History from Harvard University Press, as well as dozens of articles published in law journals and other media. He is the co-editor of the New Deportations Delirium and Constructing Illegality, Immigration Experiences, Critiques, and Resistance. Professor Kanstroom has served on the American Bar Association's Immigration Commission, the Political Asylum Immigration Representation Project's Advisory Board, and as a reporter for the American branch of the Refugee Law section of the International Law Association. After the discussion between these two scholars, we will make time for questions from the audience. As always, we will prioritize student questions and then open up to additional questions from our more seasoned audience members, both here in person and online. So with that, I turn it over to Professor Kanstroom.
Thank you very much. I'm going to dim the lights a little bit so we can see this PowerPoint a little better and allow people to eat their lunch even more energetically than they might otherwise do. We're living in very interesting times. You know, there's an apocryphal expression. I've heard that it's Chinese, but I don't know. It is, may you live in interesting times. And the debate about that has always been, is that actually a blessing or is it a curse? And we are living in some of the most interesting and challenging times that we have seen in our professional lives and actually in our lives. So it's a difficult set of subjects to talk about, but I'm honored to begin. And I thought I might just begin with a little bit of a PowerPoint to sort of frame some big picture issues. And then Hiroshi and I are going to have a little bit of a dialogue with some questions, and then we'll open it up to questions from you. Our title is evocative: States, Cities, and Immigration, What is Sanctuary in a Contentious Age? And I thought I might just begin by exploring a bit on why is this age so contentious? What about it is contentious? And then we'll talk more about sanctuary. The US case, which is the main thing we're here to talk about, is especially contentious. But I want to begin by suggesting that there are two principles that I'd like to keep in the forefront of our mind. First of all, these issues are very technical, very complicated, very policy oriented, but we're talking about real people with real lives. And we're talking about people who live in our communities with us, who go to school with us, who help us, who we are married to, who are our children, our parents. So there's an intertwining of these issues that often gets lost in public discussions about it. And I was really glad for Amanda to offer a personal piece to this. I could offer some as well, as could Hiroshi. But that's point number one. Point number two is that although we're going to use a frame of US law, constitutional law, and state and federal tensions and local law, the issues are actually inevitably global. So a large part of what we have to take into account when we talk about this is the global setting. And I thought I might just start with that. As we're sitting here on any given day around the world, there are literally billions of people who are thinking about undertaking dreadfully perilous journeys and then facing exclusion, detention, and deportation regimes as they think about leaving increasingly desperate situations. And some of these situations are politically desperate, some are climate desperate, some are poverty desperate, some are disease desperate, but that's a background norm that I think we need to keep in mind. The journeys are incredibly dangerous. Human rights workers and researchers have calculated tens of thousands of deaths in the Caribbean, in the deserts, all over the world. And the deadly toll of this movement just increases year to year. And the US-Mexico border is among the most dangerous places in the world to try to cross. That's also important to know. And part of that has to do with some intentional policy choices that were made in the 90s, but we can come back to that. On any given day, there is a massive deportation machinery and exclusion machinery that is implemented everywhere around the world. So as we're sitting here, there are hundreds, if not thousands, of people who are in processes of being forcibly removed from places to which they have come seeking safety or seeking a better life. And this is happening all over the world, in the US, in Mexico, in the European Union, in the Gulf Cooperation Council, all over the world. So this is, in some sense, a global phenomenon, as I said. And it is increasingly being studied as a global phenomenon by researchers all around the world. So I would commend a lot of that literature to you if you're interested in it. There's some very good research that's being done. It's also the case that there are millions of people who are living in intergenerational refugee camps, so-called, places in which you could find hundreds of thousands of people of whom if you interviewed a child and said, where were you born? The child would say, here. You'd say, what's your citizenship? The child has no citizenship. What was your parents' citizenship? Well, they were born here too. What was your grandparents' citizenship? In some cases, they were born there too. So we have these holding facilities all around the world. That's an important component of the problem that we've become somewhat strangely inured to, I would say. And I mention all this because I think it's important to bring some light to these things and to approach it with a kind of a fresh eye, because for me at least, by doing that, I'm regularly shocked and disturbed over and over again by what has been happening in the world, even before Trump was reelected. We'll come back to that. Around the world, there are tens of millions of people, maybe more than tens of millions of people at this point, who are called illegals or unauthorized, or in French, sans-papiers, people who lack documentation. In some places in India and Israel, for example, the term infiltrators is used. So there's various pejorative terms that are used to describe people. We can talk about the terminology of illegal, which I think refers to conduct, not people, and has to be proven in any case. But the point is there are tens of millions of people living in precarious statuses, and there are many people who thought they were not living in precarious statuses who are now living in precarious statuses, including, I'm sorry to say, people in this country with green cards, permanent resident status, and even naturalized citizens. So precarity is an expanding category. And there are detention centers everywhere. So people have been shocked to see masked US agents taking people and transporting them to maximum security prisons in El Salvador that are infamous for human rights abuses. That's not as unusual as you would think around the world. It has been unusual, thankfully, for this country, but there are detention facilities all over the world. Here are pictures of 3 of them. One is in Thailand, one is in Texas, one is in Mexico. You can't really tell the difference by looking at them. And when you go around the world, you will see differences, but there are certain features that are constant. And the main feature that I want to emphasize to you is how pervasive they are everywhere in the world. This is a current global map of detention centers. You can't even disaggregate them anymore. This map has been published by this organization for years, and every year they add more and more and more. And some of them are administrative, some of them are ad hoc, some are criminal, some are unknown. They're all housing people in immigration proceedings of various types all over the world. So that's my basic general point about the global phenomenon. And I think that leads to a second, more theoretical point, which is we're talking about problems of fundamental human nature and the fundamental nature of the nation state system. On the one hand, I refer to people, I've adopted this term homo mobilis, which originally referred to use of cell phones or something, but I think humans are moving creatures. We always have been. It's human nature. And this is why it should not be so surprising, although the numbers have been rising for various reasons, but it's inherent in human nature to move. And the fact that there's 280 million international migrants is not surprising, but you should note that this number has grown at nearly double the rate of growth of the world's population. So movement is a rising trend. On the other hand, and I say this, I mean, let me just tell you my priors here. This is a bumper sticker that I got from the last Trump administration, which I didn't put on my car yet, so maybe I'll put it on now. So I support immigration as a general proposition. I guess that should be obvious by now. But on the other hand, many of us in the sort of immigrant rights community, activist community, I think are not taking and have not taken sufficiently seriously the other inherent aspect of humanity, which is that we are rational social creatures and we have urges towards community and towards cultural continuity over time and to a certain kind of stability. And this creates a tension. And the basic tension, the basic question then has always been, can these aspects of human nature and society possibly be reconciled? And what we're seeing now is a shockingly, generationally shockingly inadequate answer to that question by almost every government that is confronting it everywhere. So this is a problem of law and public policy. It's a problem of moral philosophy. It's a problem of fundamental human nature. What we see everywhere in the world now is a chaotic collision of these principles, massive government dysfunction everywhere, and a rising tide of cynical demagoguery about all of this. Now, I want to talk about Trump briefly, and then we're going to turn to our questions. In the first Trump administration, as some of you may remember, there was the talk of the big beautiful wall in Mexico. There was the so-called Muslim ban, which after 3 iterations was upheld by the Supreme Court. There were various other initiatives and restrictions and so forth. Of course, nothing like what we've seen since then, which I'll come to in a minute. What happened in the Biden administration? There was an attempt to unwind some of that and to allow some of the pent-up demand of movement of peoples across borders to come to this country. That has then provoked a tremendous backlash, which is what we're facing now. And my personal opinion about this is that the Biden administration did a terrible job of messaging on this and explaining why people should support immigrants, and it was sort of allowing a narrative to get totally out of control, which you could see building and building and building, and that's where we are now. There's a narrative about criminal aliens, there's a hyper focus on various types of crime, and we can talk about that too as a policy matter. I personally am not opposed to certain types of deportation for certain types of people. And again, that's controversial among the immigrant advocate community, but we'll come back to that. In any case, there was that, and now we have this. First of all, a resurgence in incredibly racist, I mean, just amazing rhetoric. Lately, in the campaign, we got they're eating dogs, they're eating cats, they're eating pets. You know, that's pretty historically unique in this country. We've heard anti-immigrant rhetoric. You haven't often heard much about that. Although, interestingly enough, I will say, if you go back and read newspapers from the 1790s, the period in which the Alien Enemies Act was first passed, you will see rhetoric like this. They're coming to rape the women, they're pillaging and plundering. So there is a history in this country of some of that kind of rhetoric, but in any case, we're back to this. We're back to the wall, we're back to the migrant protection protocol, so-called, forcing people to stay in Mexico before they can apply for asylum. We're back to ending a lot of the parole initiatives during the Biden administration, which granted some status to Cubans, Haitians, Nicaraguans, and Venezuelans, people who were fleeing desperate circumstances, who were promised they could stay legally in this country for a year or 2 in so-called parole status, being summarily revoked, temporary protected status being summarily revoked. That's part of the precarity that I was talking about. A virtually complete shutdown of asylum and refugee programs, extreme interior enforcement. I'm sure people are aware that just a couple of days ago, a young woman was arrested by anonymous masked agents on the streets of Somerville, a person with a student visa, terrified by the experience. The Secretary of State said, well, she said things that were opposed to US, and a visa is not a right, it's a privilege, and if you contradict our policy, then we're going to revoke your visa and arrest you and ship you to Louisiana. Salvadoran prisons, Guantanamo Bay is being reopened, protected spaces policies that have been in place for decades. Don't raid churches, don't raid emergency rooms, don't go into public schools, all being eliminated. They're leaving it up to the judgment of agents in the field, etc. An executive order to try to end birthright citizenship and this invasion business using the Alien Enemies Act. And then we come to the second part of the talk for today, threats to sanctuary jurisdictions. So let me just turn to that. But before I do, I want to offer one more background point. Immigration law is famously anomalous, anachronistic, highly discretionary. The government has powers in immigration enforcement that vastly exceed the powers it has for criminal law enforcement. So that's an issue that has to be thought through. And it prompts this fundamental question. Who says what the law is? Now, all law students will say, Marbury versus Madison, it's the province of the judiciary to say what the law is. So that's hundreds of years old as a precedent. In this particular realm, it is particularly complicated. So a lot of what you would assume to be true in other realms of constitutional law is not quite true here. So when Holman says, we're going to make the country safe again, we're not stopping, I don't care what the judges think, I don't care what the left thinks, we're coming. The Supreme Court could uphold that kind of thinking in certain aspects of immigration enforcement. And if past precedent is any prediction, there's going to be a lot of deference to the executive branch on enforcement. So it is a real challenge. Even Justice Roberts recognized this in 2022 in the Remain in Mexico case, where he said, it is our job to say what the law is, but if we say what the law is, and then you tell us we can't do anything about it, where do you think that leaves us? So we're in a position where the courts are also struggling with their own legitimacy and the outer limits of their own power. It's a very heavy moment. And this comes to the specific point about state and federal immigration and sanctuary and federalism. First of all, most of this is federal power, but the states and localities have always been implicated in immigration law. Anybody who takes my immigration law class, we spend time on this. If you want to marry a US citizen, you can become a citizen, but marriage is primarily regulated by states. If you get a divorce, that's a state proceeding. If you're prosecuted for most crimes, that's primarily state proceedings. Aspects of health, education, those are regulated by the states. So what happens when the federal power under the, and I say under the Constitution, but as Hiroshi well knows, the actual sources of the federal authority to control immigration are a little bit mysterious, but the courts have settled on the idea that it's primarily the federal power. What happens when that runs into state policy, like making sure our streets are safe, things like that? That's part of the problem. We do have the 10th Amendment, but that's a pretty general instrument. So that comes to sanctuary. And this is a picture for those who don't know, maybe Hiroshi won't know, but I hope people in Boston would know, of Boston's Mayor Michelle Wu, who was called in to testify before the Congress about Boston's sanctuary policy. And they called her in on Ash Wednesday, which actually created a sort of double entendre in terms of sanctuary because she appeared with Ash. I think it was actually a triple entendre because she was also nursing her baby, and then a quadruple entendre because she's a child of immigrants, and maybe a quintuple entendre because she's a woman of color, of Asian ancestry in Boston as a mayor. That's the person they called to talk about sanctuary. That was pretty interesting, and I thought there were some great moments. The committee letter to her described sanctuary jurisdictions, said the committee from the House. We want you to talk about sanctuary jurisdictions and quote, they're misguided and obstructionist policies that hinder the ability of federal law enforcement officers to effectuate safe arrests and remove dangerous criminals from American communities, making America less safe. That was the invitation. And they said these jurisdictions take it upon themselves to decide what laws they will and will not abide by, all for the purpose of shielding removable aliens, especially criminals, from federal law enforcement. So that is not accurate, I would suggest. But it is true that the definition of sanctuary is quite elusive, and it's one of those terms that you hear in public discourse, but there's not a settled definition of what it is we're talking about. The term originally derives from the Latin sanctuarium, which means a container for keeping something in, or a holy place. It has traditionally been implemented by churches to shield people from various types of government action. But of course, it's taken on a more specific meaning recently. There are lawsuits, by the way, challenging the revocation of the Safe Places initiative. So there's a suit filed by Quakers and Sikhs and a group of other religious organizations in Pennsylvania. So all this is very much in the courts these days. But basically, when we're talking about state and local sanctuary policies, we're talking about policies enacted by state and local governments that do a variety of things. Some restrict state and local police and say, if you work for us, your job is to fight crime or to do whatever it is that state and local police do, but you should not be detaining people on civil immigration warrants. Let the feds do that. Others challenge 287G agreements, there's a rising tide of that, which are cooperation enforcement agreements involving federal funding with state and local police. Others prohibit some contacts with the federal government involving non-citizen detention, etc. Some forbid asking about immigration status, some restrict information sharing, some restrict local police responses, some restrict ICE from going into local jails. None of them are designed to shield criminals from immigration enforcement. Quite the contrary. Actually, there's a lot of cooperation. If a person is convicted of a crime, the state and feds will often cooperate on that. So I want to say one last thing. There's a whole other realm in which sanctuary has been evolving, and this has been through activism and people doing things on the ground and challenging the laws. This was I don't think he called himself a sanctuary worker as such, but he gave water to people in the desert, Scott Warren. And then he pointed out a direction to go to get out of the desert so as not to die. And he was criminally prosecuted for that. Federal government, this is not in the Trump administration, by the way, this is before that, tried 3 times to convict him. And his lawyer argued to the jury, being a good Samaritan is not against the law. Ultimately, he could not be convicted. There still is something in the nature of a conscience of the community out there. And I think that law can arise from that. And I think that's a form of sanctuary as well. An even stronger example, which I talk about a lot, is this French example of a French farmer who helped a group of migrants who were crossing the Pyrenees, and he was criminally prosecuted. And then he had read of things that ultimately culminated in a statement by Pope Francis about the meaning of fraternity as a global concept, that you can't exclude people because of their place of birth or the privilege enjoyed by others who were born in lands of greater opportunity. The limits and borders of individual states cannot stand in the way. Now, that's a theological position. That's a moral position. You might say that is not a legal argument. But what's interesting about the French case is that he made the legal argument that fraternity was a legal principle and precluded prosecution for helping people, and he won in the French legal system. And so now there is a precedent that stands for that. That's also, I think, a form of sanctuary. You could call it sort of a juris generative or common law sanctuary. There are other examples, but I want to leave time for talking. My own personal favorite statements are these two. One is from the Supreme Court in 1945, following a period of enforcement that is not so dissimilar to what we're seeing now, although there was a war going on at that time. And Justice Murphy said, we have to zealously guard the rights of the most humble and the most unorthodox among us, because that protects the freedom for all of us. And then the idea that there is no road, the road is made by walking, and that's from a well-known poem in Spanish. Let me stop now, and then Hiroshi and I will sit down and we'll have a question. I have some questions for him, and then we will open it up to questions from you. Thank you very much. So, Professor Motomura, who, by the way, there are few people in the world who I admire more than Professor Motomura, let me just tell you. You were very lucky to have him here. So if that's not too much of a setup for you. What do you think about the legal sanctuary, and how do you define sanctuary? What is it that you think we're talking about?
Yeah, first of all, thanks so much for here for coming out today. I really appreciate it. And as you say, it's an urgent time in a lot of different dimensions and different ways to think about urgency. So I really appreciate and really eager to hear what you have to say. What you care about, what you bring to this conversation. So definition of sanctuary, I mean, it's an interesting term, and I was thinking, should I give the short answer, the long answer, or the longer answer, or the longest answer? But let me keep it crisp for now. It's an interesting word because it's one of the few words that I know of that is used by both sides. One side as an epithet, an accusation, and another side as a badge of honor. And a lot of words we talk about don't quite have that sort of valence to it. I think it's interesting to reflect on that. Let me tell you what actually bothers me about the word sanctuary, and I tend not to use it. But we can talk more about why. But let me just give you kind of a first take on it, and that is that if we go back to Dan, what you were saying about healthcare, about criminal law, about family, there's a whole bunch of ways in which the law interacts with people in a community, and some of them are more explicitly inclusive. I mean, they could range things like in-state tuition for public education, public higher education. Another is that it could have to do with driver's license and ID cards. It may have to do with healthcare provisions that are more inclusive than what the federal government or indeed what the state government might provide. And then there are a lot of regulations that we often call immigration law, having to do with status, and it's often said that only the federal government can grant a green card, can grant temporary worker status and things like that. But for me, a lot of the more inclusive things are really one way to bring people into a community and to recognize them, to either foster their belonging or to recognize their belonging, and often both. So to me, to look at sanctuary is to focus on enforcement oftentimes. A lot of people who are in the sanctuary movement will define sanctuary as is neutralizing enforcement, maybe resisting enforcement, but the dimension of conversation is how do you feel about enforcement? But what to me that excludes the idea that it's really that sanctuary and enforcement focus is only a part of what it means to have people in a community and to recognize them to one degree or another, or to reject them in one degree or another. And so to me, when a city issues ID cards, when a state offers driver's license eligibility and things of that nature, that's also a form of sanctuary. So that's a much broader definition of sanctuary than one often hears. And I can say more about one part of this, but let me just start my answer with this one statement, and that is that I think sanctuary is more than what you see in the enforcement dimension. I think it's really about a way of defining a community that goes beyond enforcement. And so I want to include the whole host of things that cities and states can do in defining sanctuary. And if that's a definition of sanctuary that you adopt, then the word sanctuary doesn't bother me. But I often resist, or at least am a bit of an objector to conversations where sanctuary is assumed to just be about enforcement. More to say, but that's just kind of the, believe it or not, short answer.
No, I think it's a good way to start. I noticed that Mayor Wu, when she began her statement at the House, which, by the way, if you haven't seen that, I think it's really worth pulling it up. Not just her, there were 3 other mayors who were there, but I thought she did an excellent job. And she began sort of along the same lines by, when asked about sanctuary policy, she said, first of all, I want to say Boston is an immigrant-friendly jurisdiction. Boston was built by immigrants of various generations, and this is a very important component. So not just a resistance negative policy against enforcement actions. She also made the point that a large part of the reason why Boston and other cities have sanctuary laws is to facilitate the provision of other services to all members of the community, so that we can't actually have effective police enforcement if non-citizens are afraid to talk to police or afraid to open their doors, or if you start having masked agents coming and swooping people up in apparently arbitrary ways, then all sorts of crime gets compressed and repressed, and people don't feel like they're part of the community anymore. You can make the same point about emergency room care or public school education. So maybe we could talk a little bit more about how you think it has evolved to the current state of the debate. I mean, there were famous prosecutions of sanctuary workers. This is before most of the students here would remember, but during the Reagan administration, there were some very famous episodes of church workers who expressly called themselves sanctuary workers, who helped people and who were then criminally prosecuted. I have the feeling that that may be around the time that the meaning of the term started transforming a little bit, but could you talk a little bit about the long history of this concept?
Yeah, I'll start, and then I'm sure that there are aspects of this that to get a full answer, you may have to combine both of our memories of various periods. But I've been thinking about how the term has evolved, and going back to what I was saying about being troubled about an enforcement focus. I've been thinking about how immigration policy debates have evolved in general terms over the last, say, 20 years. Or maybe it goes further than that. But I think right now we have a rhetoric that casts immigration law. Well, the one word that appears I think in almost all the executive orders now is invasion. And ties into what you're saying, Dan, in your slides, is that and so that's a way of thinking about immigration law, and it's worth thinking really about how one frames the function of immigration law in general. I think that what has happened over certainly the last 10 years, is the notion that immigration law is some legal version of a physical border wall, which is to say, immigration law is a dividing line between us on the inside, and them on the outside. The function of the wall is to keep invaders out. The function of the law is to keep invaders out. And so what happens is that when we're dealing with immigration enforcement inside a city like Boston or anywhere else, what we're really doing is picking up the mistakes that were made at the border. So the whole construct is one that lends itself to either characterizing this as an invasion or declaration of emergency or an anomalous zone where the normal rules of justice and indeed of morality don't apply, at least not in the same measure. So I think that one of the things that's happened with the idea of sanctuary is that it has served as a rhetorical device that, if allowed to be all about enforcement, fits into this notion that we're going to protect you by building a higher wall or by having more ICE agents arrest people, even with green cards. And the sanctuary is a term then that becomes very easy to target as the anti-enforcement, which is the allowing invasion to persist. And I think that that has intensified as a use of the word sanctuary as an epithet. And it quickly moves from to we have a set of laws and physical measures to protect you. Sanctuary must be undermining those measures. And I think that that kind of fitting of sanctuary into the larger politics is more pronounced and more intense than it was certainly 10 or 20 years ago, when I thought there might have been more room to think of this as communities acting within communities. And so that's just one dimension of, I think, evolution, but I think that different way to say, in a sense, what I've just said is that the immigration politics has shifted in a way that has allowed the word sanctuary to be an epithet, at least to a certain part of the American electorate who's pushing for stronger immigration enforcement, and with that enforcement being in a very exceptional manner.
I mean, I remember talking to people in Europe in 2015, 16, 17 about how the word migrant had become an epithet, which
Right.
I always thought was a fairly general term of scholarship, and then how the word asylum seeker became an epithet,
Right.
and refugee became an epithet, and all these moments of fear and pressure create such dissonance for a lot of the terms that were used. I want to come back to the question in a minute of how you think state and local governments could actually engage with this, because there's a certain tension between advocates saying, I want them to not be involved in this at all, versus I want them to implement sanctuary policies or be actively engaged in some particular vision of immigration law implementation.
Mm-hmm.
So, but before we get to that, I want to ask you the sort of question that could cause you a problem when you're flying back to California, which is, what do you really think is going on here? Why do you think this administration is devoting such energy and enthusiasm and such kind of spirit, not only to enforcement, but to the particular targeting of so-called sanctuary jurisdictions, particularly the cities? What do you think is really at stake here?
I think a lot's at stake, and it's worth focusing on. Let's just focus on the rhetoric of mass deportations, right? What's blocking the administration from deporting millions and millions of people, 10 million people, whatever it may be? I think it's useful to think about at least 3 different types of obstacles to mass deportations. One is operational. One set of obstacles is operational. One set of obstacles is legal. And one set of obstacles is more political, having to do with, and that's the level at which we're dealing with vision and narrative. On the operational side of things, one of the things that's often cited is, at least in general terms, is that under the Trump administration, fewer people were deported than under Obama. And
Could you say that again?
fewer people were deported under Trump 1 than under Obama. And so why is that? Well, I think one of the reasons is these measures that we're calling sanctuary or welcoming city, or measures, in other words, the lack of cooperation on the part of states and cities. And so there's an operational targeting going on here, is that if we could only essentially get the resources of state and local police or governments in general to not only arrest people, but also to act in a way that causes them to, quote, self-deport, end quote, then operationally that's hugely significant. And much of what we're seeing today is the idea that if you make people feel unwelcome, a certain number, especially perhaps more newer arrivals, according to a story, I think it was New York Times this morning by Miriam Jordan, the notion of self-deportation. So operationalizing.
Which, by the way, has a long history too. I mean, I remember William Sapphire arguing that to make them so
Deport.
miserable that they'll self.
Yeah, and Pete Wilson in California argued that as that's really the purpose of Proposition 187. If we make people feel uncomfortable, they will leave. Which, by the way, is one of the reasons why I'm thinking that sanctuary should not be just focused on enforcement, right? Sanctuary, in a broader sense, ought to be focused on those things that make people feel welcome or not. But so operationally, states and localities have a tremendous role to play in making people feel welcome or unwelcome. And they have a particularly operational role in magnifying the effectiveness of federal police, right? And so Chris Kobach, who was the drafter of and in a sense a mastermind of many of the strong state and local enforcement policies, he talked about state and local police being a force multiplier. That was the term he used for a force multiplier. Force multiplier was the term he used for the mobilization of state and local police. So that's the operational part. I think at the legal level, there are obstacles to federal cooperation on policies toward non-citizens, put it more generally, that I think where sanctuary may be a place where the administration sees itself as increasing the scope of federal power. I don't know how that'll turn out. It's a different level of argument than the operational, but I think sanctuary is a target for minimizing the role of states and cities. And I also think that at the level of politics, of vision and narrative, I think it's interesting to think about states and cities as being the locus of a lot of important decision making. Because a lot of what we're seeing, especially in cities, but also in states or regions of the country, is a very different attitude toward people coming to the country. I hesitate to use the word newcomer because many of the people we're talking about have been living without status but working for 20, 30 years.
There was just a person arrested who had 50 years of green card. They discovered like an old embezzlement conviction or something.
Right, and then you had TPS holders who've been in the country since since the 90s, and of course with many who are children, or that's the whole issue about who counts as a citizen anymore. So this is all kind of different facets of seeing executive orders and other actions from the White House being part of an entire set of things. It's hard to look at any of them in isolation from each other. But the idea really is that the state and the city is I shouldn't use operationalization here because it's really it reflects a vision of what this country should be. And in a sense, I think for a lot of people in the White House, that vision of the welcoming city is actually quite subversive. And so to sort of make sure that doesn't spread or become the vision that's dominant, I think is part of what's going on with mass deportation. But the reason I cast this as an obstacle to mass deportation is because there's a lot of resistance and potentially more resistance at state and local levels, not to the legal part, not to the operational part, but also to the political resistance that comes up when you deport 10 million people, because then, of course, it's not just your employees and your students and your professors, but it's also your family members.
So when you talk about the resistance, I wonder if we could talk a bit about the legitimacy aspect of this, because there was famous history in Boston, for example, of opposition to the fugitive slave law enforcement by people on the ground here in Boston. If Boston students don't know about this, I encourage you to look into it, where there was real on the ground, active, sometimes violent resistance to agents coming in and seizing fugitive slaves and trying to remove them from Massachusetts. I think at that time, the legitimacy argument was pretty clear. I mean, most people in this area, not all for sure, but a lot, opposed slavery in general and felt that sort of federal enforcement was really an imposition of the slave system in a place where it was really not wanted. Deportation is much more complicated. And as you know, I've always sought to differentiate different forms of deportation, and the administration seems to be conflating this. So every resistance to every form of deportation, including temporary protected status or grants of parole or people who are crossing to work in the fields in California, is the same as supporting Tren de Aragua criminal aliens who are murdering and raping across the country or dealing drugs or whatever. So could you talk a little bit about how you see that legitimacy strength? And I think it gets lost in public debate a lot.
Yeah.
And a lot of the sanctuary jurisdictions say, look, if you've got somebody from MS-13, we will cooperate to get that person out of the community. But if you're talking about stopping people on the streets of Chelsea and saying, show me your papers, we will not cooperate in that.
That's a question of many different levels, and the one that I immediately gravitate toward or label is almost a philosophical one about and maybe the historical one, as you expressly invited. And abolition is an interesting, it's an interesting history in this respect, and I totally endorse thinking about it in this moment. Now, you know, I've been around a while, but I wasn't around then. And
I was only very young myself.
yeah. And it's interesting how we think about that period of history now, because in retrospect, it seems plain that it's different. I just don't know if it really was so different then. Or a different way to think about it is, how will people think about the current episode 50 or 100 years from now? Digress slightly, but I don't think it's that much of a digression. I think about DACA. I mean, the Deferred Action for Child Arrivals, announced by President Obama in 2012. I recall from the run-up to DACA.
These are the dreamers. Those are the people.
The dreamers, the people who
came
got
as children.
The people who came as children, deferred action for childhood arrivals, and they got eligibility for work permits and a reprieve from any immigration enforcement action for renewable periods of 2 years. And it's as a practical matter, it's phasing out because of the hold. The hold is a practical matter on new approvals. Okay, but it is not getting a green card. It is not getting any kind of a durable federal immigration status, but operates very effectively to allow basically somewhere between 600,000 and 800,000 people to get an education, to be actually, you know, professionals and even middle management at this point in a lot of employment situations. And I recall how revolutionary that seemed, and I think my first reaction to this was, that'll never happen. You know, it just seems it's so contested and that kind of thing. And yet for many people, once it happened, it seems so natural. How could we imagine a world without this? That didn't mean it was uncontested. It was certainly contested. But, you know, part of this is the contingency of how we apply moral frames to something that happened long ago in history. And you know, historians try to unpack that, but I think I'm not so sure that, you know, that the moral character of abolition was so clear then, but I'm also wondering how we will think about this episode now. And you have to unpack that, right? Because you have to unpack, I think, what it would take for my interpretation of history to become more dominant would be really rethinking how it is that we have 11 million people or 14 million people in the country with status. Because I put a lot of weight on that history. And that's, I have to confess, the reason I do not think of legal status or lack thereof as the end of the conversation. It's just the beginning of the conversation. I think to adopt that policy or that view would require you to adopt a certain history of essentially US labor policy over the last 120 years, or maybe since the beginning of the Republic. And that's what it'll take. But I can see a world when that does happen. I'm recalling that the time when, you know, I was in Berlin, and if those of you who've been to Berlin, there's a park that is a preserved part of the Berlin Wall. But I'm old enough to remember going through Checkpoint Charlie and Friedrichstrasse and all those places where you had the guards with the guns and people died. And I saw this, I'll never forget this. There was a group of middle school students, sounded like they were from Holland. Well, I don't know, don't worry about that. It doesn't matter. What matters is what they said. The teacher says to the kids, you know, there used to be a wall here. And it just struck me that they were born so far after the wall that the idea that there was a time before and the morality is that they saw it, maybe a lot of people see it now, was and the precarity of that obstacle was seen as eternal. The precarity of the obstacle was really far off in the distance. You know, so I think it's an interesting kind of this is why I take the philosophical question too, which with some operational significance, but the philosophical question is how we think about history and the morality in the moment that we're in historically.
And now you could go to large parts of Texas and Arizona and tell your children there used to not be a wall here.
Yeah,
So
it is
it
true.
moves in both
It
directions.
is true.
I was also struck by the operational point that, Christy Noem, who's the head of DHS now, was just in El Salvador examining the facilities, was the governor of South Dakota, which has a huge beef packing industry. And she said, we're just going to deport all the illegals from South Dakota. And then large cattle operations said, well, one of them in particular said, if you do that, we're going to drown in our cows because there's nobody to work in the meatpacking plants to chop up the beef. And we've been raising the beef and moving it to slaughter. And if you deport all these people, we're going to drown in our own cows. And I always thought that's an important metaphor here because a large parts of this country will be drowning in cows or drowning in roofing jobs that can't be done all over Newton or lawn care in Los Angeles, et cetera, if this actually happens.
Yeah, or hospitals, wherever it may be. But that's why, that's why I mentioned earlier the idea of the political vision narrative obstacles here, because the state and local space, the sanctuary, whatever term you want to use, space is a place for developing what that vision might look like as a counter vision. And those are, and this goes back to what immigration law actually does. It's, to me, it's not just about, of course, the border matters, but it's not one to focus on the border as much as how we build communities in this country, especially in the system that has operated in a way that very predictably many millions of people would be here without papers and yet be essential in some sense for, for whatever it may be where they're working.
Okay, so let's open it up for questions. I want to emphasize that we welcome critical questions as much as friendly questions, maybe even more.
Yeah.
And you don't know if it's critical or friendly, but nothing is out of bounds. We're a university. We believe in free speech. So ask your question. We will give some priority to students who have questions. So first, if any students have questions, I mean, current students, with all due respect to former students who may be here. Questions? And please say your name before you.
Hi, I'm Caitlin. I'm a 1L here. There's been a lot of movement with shield laws, so interstate shield laws, especially for healthcare, for abortion rights or gender affirming care. And that's been a lot of state to state activities. So doctors conducting themselves in ways that are legal in Massachusetts, but maybe seen as illegal in Texas, but Massachusetts can determine what is legal in its state and protect them. Are there viable options for something similar when it comes to immigration due to the?
You're talking about like the mifepristone stuff where somebody is indicted in Massachusetts for prescribing something in Texas?
Yes, and so similarly, Massachusetts has protections of like non-compliance or not enforcing certain aspects of it, but it's different with federal, like supremacy. And so do y'all see any viable strategies or options for shield laws? That's almost like a different form of sanctuary.
He's the right person to ask.
Well, let me give you an answer that is, I think, incomplete, but it may suggest something. And I invite other comments. Dan, what do you want to add to this? So the center that I'm the faculty co-director of, we're involved in some of these, a number of things that you read about in the news. And one of them that may not be as much on the radar is that we believe that IRCA, the 1986 law, part of which it has the whole system of I-9s and employer sanctions and things of that nature, that it does not apply to states when states are the employers. Because that law does not mention states as being the entities, include states within entities that are not allowed to hire without using the I-9. And we base this on a lot of things that I could talk about more, but the basic idea, though, is that we believe it is a sound legal theory. And in fact, we're representing two people. Our center at the UCLA Law School are representing plaintiffs in a case in state court that basically is trying to establish the principle that people cannot be excluded from hiring a California state government on the basis of immigration status, except when required by federal law. And we're saying that this is not required by federal law. It's interesting to be counsel in a lawsuit against your employer, but be that as it may. But
Your
that
employer being the state of California.
being
and
University of
UCLA.
California, yes. Basically, we're counsel against our employer for not hiring undocumented students because we don't believe federal law prohibits the hiring of undocumented students by state employers.
But if an executive order comes down that withholds state funding.
Well, that's part of the politics of this, right? So different levels here. I mean, Congress could amend WRCA. Our position is that an executive order would not change the limited nature of WRCA. But on the side, there's a tremendous amount of apprehension among, and I could talk more about that too, because that's a whole thing about sort of how people are reacting to state and local level to federal threats, including funding. But it's interesting, in a way, it strikes me as very narrow along the lines you say, but it also points to something broader. A more general application of maybe not operationally legal mechanism, which is that there is some space and even statutory and constitutional recognition of state power. I'm also recalling the law in Utah that basically pushed the federal government to grant temporary worker status in order to, for workers in the state of Utah. But I think they recognized that they could only go so far. So the one example I give is when we believe you can go that far, but I recognize it's limited, but there may be more of a political power in that move.
But I would say, I mean, the example you give is a horizontal problem. And what we're talking about is more of a vertical or a triangular problem, because you have the problem of what is the maximum extent of federal enforcement as against the states. And there it becomes more problematic. Although, ironically enough, during the Biden administration, many of the state actors who are now, heralding federal executive orders were resisting federal enforcement. Texas, for example, by enacting their own state laws to enforce status. So, it sort of depends on whose ox is being gored, and there is politics in this all the way through. Other questions? There's one. That's a student.
Thank you. My name's Portia. I am a student in your class. And I'm wondering how you drew this division between immigrants who have committed no crimes and people like the ones who've been deported from Trente Aragua, who we view as somehow less deserving of the protections that the United States can give them. Under human rights conceptions of what they're entitled to, no matter their citizenship status, how can we draw that distinction and say that some people are more deserving of human right protections and others are not because of some things that have happened in their life? We've seen how horrible the prisons in El Salvador are. There's people who are being tortured on a regular basis. There's their supermax prisons. Even if someone has committed a crime, aren't they still entitled to the protection against those abuses under international law, under non-refoulement policies? Like, this is something that feels so human, yet we're okay drawing a distinction just because someone has committed a crime.
Thank you, Portia. As you well know, I certainly do not think that people forfeit their human rights as a result of criminal conduct or criminal conviction or anything of the type. My actual bigger point, and it's probably more theoretical than we should get into today, is that there are different theories as to why deportation is at all legitimate when undertaken by a nation state. And in fact, I tend to agree with you that deportation of people who have just crossed the border is more directly linked to state sovereignty than is deportation of people who have green cards, have been here for long periods of time, and who are accused of various forms of conduct. Having said that, my own feeling about it is that everybody has due process rights. It's a question, but due process rights can be flexible and can differ with the nature of the proceeding. So if a person is in fact being deported for crime, First of all, I think they need to have all the panoply of criminal rights protections in the criminal system before they get convicted. The right to a jury trial, the right to a lawyer. There's no differentiation between the rights of citizens and non-citizens as to that. And secondarily, again, this is just my opinion about this, is that then deporting them for the very same crime is equivalent in many cases to a form of double jeopardy or a different type of rights violations, and the government should do one or the other, but not both. In this case, what the government is doing is the worst thing, which is deporting people who have not been convicted of any crime at all, who have been identified through some nebulous standard by an agent in the field, perhaps because of a tattoo of their mother or their violin teacher. I don't know. Some of them are in a gang. Can you actually target people for enforcement because of membership in a particular organization? That's a complicated constitutional question, but I do think it raises a lot of profound human rights concern. And just to be clear, the idea of sending people to a black hole prison in El Salvador, which is famous for human rights violations already, I don't see any scenario in which US courts should allow that to happen at all. But we'll see what happens. It's all being challenged.
Yeah, I would just add that in many cases, the risk or even the certainty of some people being shipped out on this basis, the people are being targeted incorrectly, wrongly, that people are associated with something for some reason that would later prove not to be true. It reminds me of what's often said that, you know, you'd rather better that X number of guilty people go free than one innocent person be convicted. And so, given that legal process, or maybe it's a human frailty that we don't know for certain, what I think what's going on is a complete flipping of that. It's almost as if better that it's fine if it's fine if one innocent person be subjected to this, as long as we get 9 guilty people.
In fact, they say that. They say, why are you whining about the one innocent? We got rid of 10 gangbangers.
Exactly.
Don't care about that.
And so that's really what's at stake. It's not like it's not a completely binary certainty, yes or no, but how do you manage risk? How do you manage the doubt? And that's, of course, that's the essence of tough decisions about due process.
Also, just to come back to your point, one of the things about massive immigration enforcement is that it inevitably infringes on everybody's rights, because when police are routinely asking people, show me your papers, either they're going to do racial profiling or they're going to ask everybody for their papers. I was born in Brooklyn. I don't have my papers. Like, I don't even know what my papers would be. There's a new executive order that you have to have proof of citizenship to vote, but a birth certificate apparently doesn't count as sufficient proof of citizenship to vote. I don't know what's proof of citizenship to get an ICE agent to stop asking me questions on a bus. So this enforcement is really problematic, because you can't tell by looking at people or listening to people whether they're citizens or not, what their immigration status is or not. And part of the strongest argument that was made against state enforcement of immigration laws was that it's really complicated. We both teach a lot of courses in this, and if you, as students, take any of these courses, you'll quickly see it's really hard to figure out if a person should be subject to deportation, or if they should have certain relief rights, if they should get bond, all those things. So the idea that we're doing this on sort of a fast track, quick trigger thing, and then sending people to El Salvador is problematic in a lot of different ways. We have an online question.
We do. We have students online too.
Okay.
Yeah, so this is from a student named Benjamin Scott from University of Kentucky. And he asked, how do you think sanctuary cities within red states or states unsupportive of their policies will react to threats of legal action from the federal government? Louisville, for example, is the only sanctuary city in Kentucky. So do you think cities in similar situations may be more inclined to abandon sanctuary policies?
Yeah, that's a great question. What do you think?
Well, where I start with that, I'm not sure where this answer is going to end, but I'll start by saying that the relationship between states and the federal government is, as a legal matter, typically different. There's more dependence of states from the federal government than there is cities from the state government. In other words, different states give different cities and counties and school districts a certain degree of autonomy, but it typically does not approach the autonomy that the federal U.S. Constitution gives to states. Right. So it's often said that, and often argued and upheld that, federal government cannot commandeer state resources or local resources, but states typically don't have that kind of protection. And so I think that,
I mean, cities don't have that.
I'm sorry, yeah, I
State.
misspoke. Cities don't have the protection against state governments. And so, in many states, the states can effectively commandeer state government. So let's start with that. So it means that the state governments can exercise more leverage or even command things at the local level. And that makes that makes things hard. We've seen some states enact provisions that are basically anti-sanctuary.
Texas, I think, has done.
Texas has done that. Yeah, so that's one way to think about the difficulty of that. I don't know. That's just a start to an answer. I'm not sure it really is an answer, but it is. I think it's an important piece of understanding what's at stake.
Well, you know, I would also say, I think it's a great question, and in one sense, it's a very political question. It's going to depend on the nature of advocacy and organizing at the local level. Like in New York, you have a very dominant city and a relatively weak state government by comparison in some ways. In Texas, you have a relatively robust policies, sanctuary policies in Austin and Travis County, but you have a very strong state opposition to that that's willing to mobilize against it. So there's that. But ultimately, a lot of this comes down to questions of where should these policies be made? You know, like how does democracy function at the local level, the state level, the federal level? How do we calibrate those relationships? And this comes back to also, are there some things that are just law-based too? I mean, is there some realm that can be protected from even democratic intervention by a state government as against a city? Because the city and communities inherently have certain rights vis-a-vis certain types of policies that affect people at the local level. I mean, a lot of this is really uncharted water. A lot of it is old water that has not come up recently, but I think it's plenty of fertile ground for law students and lawyers to sort through. I don't know about Kentucky. I think Kentucky is interesting because it seems to me that the governor of Kentucky is actually trying to establish a sort of purple identity. So that the politics in that state, which I don't know much about, but could be quite interesting to watch. Yeah, well, let's take one live and then we'll take another online.
Hi, I'm Amber. Thanks so much. So my question is about, we've talked a lot about, you know, things on the ground in states and cities. One thing that hasn't come up that I'm wondering what your take on is issues of data privacy and electronic surveillance. I mean, Mr. Khalil at Columbia, people knew about him. There's speculation or maybe evidence that Ms. Ozturk at Tufts is something that there is a website that, you know, third parties compiled that brought her to the attention of ICE, even though they're obviously looking for excuses. One, just kind of what is your general take on the role that maybe states and cities could have with that sort of thing? Obviously, there's, you know, federal supremacy issues, but states like California have fairly robust privacy protections on the internet, and we know that the government buys lots of third-party data that's kind of available for free. So is that a potential place where kind of an idea of sanctuary might be useful, that something like state governments could take advantage of if they had the political will?
I just, by the way, deleted all my genetic data from 23andMe. My wife gave me as a birthday present 5 years ago. Anybody who's interested in researching my genetics, it's too late.
Well, actually, that gives me more concern and more pause than it gives me comfort or potential. Sorry to.
No.
And here's why. There are a lot of places where the sharing of data in ways that are not known and not knowable and changeable in the future are much more pervasive and much more intertwined than firewalls might lead you to believe today. There's several examples of this. I mean, one of them, maybe the background example, is all the data, whether it's 23andMe or whether it's your Google searches or whatever it may be. I mean, there's a lot people know about this, and I'm not sure it's cabined between federal and state government. In fact, it's not cabined between them and private enterprise, right? And so, for example, that there's so much of this controlled by private companies in various forms, ranging from shopping to 23andMe, that really crosses these boundaries, right? And so it could be that that LexisNexis is really a bridge between state and federal database accumulation and management. So that's one thing. Another example, which is a different sort of thing, but it's actually an example of the same phenomenon, which is that much of the interconnection between federal immigration enforcement and on the one hand, and state and local police on the other hand, has to do with the running your identity through federal databases if you get stopped, and to see if there's a warrant out for you, because that information and then could reveal your immigration status. And so it becomes a part of every traffic stop, or at least depends on the degree of seriousness of the encounter with law enforcement, but it could come out that in fact you're exposed then as having an overstaying a visa or something like that. And so that's a way in which a state or a city that says we're a sanctuary city or state actually is part of an enforcement system where if you run someone's driver's license number through a federal database to see if there's a warrant, that actually is an exchange of federal of state and local identity information with federal databases that include federal databases that they use for immigration enforcement. And you see a lot of this in the collection of the CBP Act and collecting data and things like that. And some people, and it's for all this the sanctuary rhetoric that you sometimes in language and policies that you sometimes see, it's not that widely known how complete federal government's collaboration is with international student offices. And of exchanging data about when a visa, when someone's going to graduate, or when their course load drops below the number of units and stuff like that. And that's kind of, I'm not sure if people really, or certainly people are less aware of that than what the policy is when an ICE agent shows up on campus.
Yeah, there's also a big background question, which is, does the First Amendment protect non-citizens at all, or to some depreciated degree, or does it depend on status? Marco Rubio is essentially saying that if you're on a student visa, even though the statute says the Secretary of State can revoke it if it would have serious adverse foreign policy consequences, that's what the statute says. So we'll see what the courts say about whether the law limits his discretion at all. But he's basically saying if you posted something that is arguing for divestment or supporting Hamas in some oblique way, that's enough to revoke your visa. So there's a pretty profound First Amendment question there. And others are being deported, even people with green cards, for participating in public demonstrations. So the lawyers are arguing the government needs more than that. They need to show some actual conduct in order to deport people. This was engaged in during the Nixon administration. There were cases during the McCarthy era. There were cases actually during the Alien and Sedition Acts that never made it to the Supreme Court then. But we'll see. I mean, the Supreme Court is going to have to resolve that. So there's that. One thing I do know for sure, and this is true, by the way, whether you're a citizen or a non-citizen, if you travel abroad and you come back through an airport, you have like basically zero privacy rights in your laptop or your phone or whatever. So beware of that too. That's also because of customs enforcement as much as immigration enforcement. Well, that's a happy note. Do we have any other questions? We have one more online. Maybe we'll take one or two more, and then we should probably think about vacating this room before.
I think we have a final question online, and it's a big one.
Okay.
But maybe you can spin it toward a happy, hopeful note.
Okay, I'll try my best.
Can you speak to the increasing entanglement between our immigration system, criminal legal system, and the militarization of law enforcement, and the evolution of these systems in a time of a growing tech industry?
Yeah, that's actually a very profound and important question, because for me, at least, part of what I'm noticing, and it's sort of going under the radar a little bit, but this use of military aircraft, this masking of arresting officers, this invocation of national security at very much lower levels than has historically been the case, this removal of people outside U.S. territory it all feels military. And we had talked for years about the increasing intertwining of the criminal system with the immigration system, and that raises all sorts of questions and issues. But I think this tripartite thing, in a way, a lot of the enforcement is actually bypassing the criminal system now and going straight to the military and the national security model, which is something we have not seen. We saw something like this after 9/11. There were ramp ups of things that looked like this to some degree, but actually, I think what's happening now is even more robust in some ways than what was happening then.
Yeah, I think what happens, and this is very consistent with what you just said, and it goes back to what I was saying earlier about sort of, the word invasion being used very freely. We have ways of understanding what is fair and what is just. And from that come all kinds of things, whether it's the US Constitution or contract law or civil procedure or all the kind of things we learn about in law school. Often the battle is not in defining those things, the reach of whatever might be the First Amendment. One of the ways that you could act free of those constraints that have been developed over certainly centuries of time, whether it's due process or discrimination or whatever it may be. One of the ways you can exempt yourself from those constraints is to create, I suppose what some people call a zone of exception. I mean, sort of an area where the normal rules don't apply. How do you create a zone where normal rules don't apply? You basically define it or have a narrative that makes normal rules not apply, and then you have words. The words are military, words are invasion, words are incursion, hostile forces, things of that nature.
Terrorist, national security.
Terrorist and national security is a big one, and that really comes up, I think, immediately after 9/11 at a time that consists. And also a war, right? It's the war on this sort of thing. I mean, the war on blank is a very powerful way to create an exception to normal rules. And so I think that's the kind of that's what we're going on here. But then it gets to the use of data and as a way that actually facilitate that in ways that we don't know, actually. Especially because the data lives in some sense forever. Sorry about that in terms of 23andMe, but it's backed up somewhere or has been replicated somewhere.
I was afraid of that. I saw a guy who looked like me the other day and where he came from. On that note, I was just thinking, David Cole, who was a Georgetown law professor, still has been working with the ACLU, wrote a book called Enemy Alien during the last period. And he pointed out that it's really easy and cheap to trade somebody else's rights for your security. But when government starts to overreach, which is what inevitably happens in these periods, and citizens start feeling it, then resistance, and then we rediscover the principles that we created in the first place, why we created a constitutional democracy, why we created tripartite government, what the fear was of George III, why we didn't want to have a mad king. So if there's a note of optimism, I think that the turf of that, the underpinning of that is still pretty resilient in this country. And I have some faith that the people will rise again and put some restraints on excessive invocations of things like invasion and war and so forth.
I agree, especially because as that rhetoric is used, there are many more people who truly feel directly affected.
Yeah. So on that note, we will end. Thank you all for joining us and the right thing.